believe you're entitled to 10 minutes of oral argument. If you wouldn't mind putting your name on the record, please.
I'm the executor and sole beneficiary of the trust and estate of Mr. Kevin Dwayne Craft, the legal persona.
What you're about to witness is one of the boldest sovereign citizen courtroom moments we've seen in a long time. Today's case isn't your everyday traffic stop or driver's license dispute. No, this man has taken his crusade all the way to the Michigan Court of Appeals, and the stakes are much higher than a speeding ticket. He's arguing that the state has no authority to make him support his own children, that courts are actually corporations, and that DNA testing is a business contract he never agreed to. In other words, he wants the benefits of parenthood without the responsibility, and has wrapped that argument in sovereign citizen legal jargon, corporate entity buzzwords, and constitutional references taken wildly out of context. The judges is standing in front of. They are not amused, and they are about to put his arguments through the legal shredder.
I'm not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for that summary judgment, please.
You've asked for.
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter, and then at some point in the future we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce jurisdiction on?
Right here, we get one of the classic sovereign citizen opening moves, the special divine appearance. This phrase is often used by sovereign citizens who believe that saying certain words magically changes the court's jurisdiction over them. In reality, whether you call it a divine appearance, a celestial appearance, or an intergalactic appearance, the court's authority doesn't change. The judge immediately reminds him that this is not a back-and-forth debate club. The Court of Appeals isn't there to answer hypothetical questions or indulge philosophical speeches. It reviews legal rulings based on established law. What's interesting is that even after the judge patiently explains this, he keeps trying to interrogate the court rather than argue his case. That's a pattern throughout sovereign citizen litigation. If they don't like the rules, they pretend different rules exist. And already, the red flag is obvious. He brought the case here himself, yet is questioning the court's legitimacy. It's like calling a restaurant to place an order and then asking whether telephones exist.
We're acting under the state constitution of Michigan of 1963.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits, and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kirnar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people just representing themselves. And that's what took place in this matter. In Article 1, Section 17 of the Michigan Constitution prevents courts from ignoring motions and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities' liability under the Section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant. That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I denied any consent or any contract with the state or Title 4D agency to give away my biological and genetic material.
Here we see one of the biggest contradictions in sovereign citizen logic. He filed the appeal. He invoked the court's power. And now he's arguing they don't have jurisdiction. Courts don't gain authority because someone consents. Jurisdiction comes from law, not personal belief. The judge clearly explains that the court's authority is both personal and statutory and grounded in the state constitution. But instead of engaging with that legal reality, he tries to divide the world into maritime law, tribal law, and common law fantasy court, as if choosing legal systems is like browsing a Netflix menu. What's actually happening is simple. There is a child support case. There are children who legally deserve financial support. The state has the power to enforce that obligation. And now is stuck trying to argue that none of that applies to him, not because of facts, not because of law, but because he simply doesn't like the outcome.
That the case Monell is relevant because it underscores the importance to ensure that government agencies like the friend of the court on this context. These are for-profit agencies disguised as government agencies like the friend of the court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked, what is the constitutional court? The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirement. I see that they're not here today, and that's some questions that are raised, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnosis Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers, 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test, and if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarm.
Now we reach the heart of the matter, DNA testing. He argues that ordering a paternity test is an unreasonable search under the Fourth Amendment. On the surface, that sounds dramatic: genetic material, privacy, bodily autonomy. But in family law, courts have long recognized that paternity testing is lawful when child support, custody, or parental rights are at issue. Why? Because the court has a compelling interest in knowing who is legally responsible for a child's well-being. He frames the testing as business contracting, but it's not a business deal. It's a court order tied to parental responsibility. And refusing DNA testing doesn't make the case disappear. It usually strengthens the assumption that he's the father. Notice how he never once focuses on the children involved. The conversation is entirely about his sovereignty, his paperwork, his rights, his refusal to consent. Meanwhile, child support isn't about punishing parents. It's about kids having food, housing, and stability. That part seems entirely absent from his argument.
The state of Michigan is also a business. And with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost if I was going to be responsible. I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice of court to refusing to appear voluntary. And I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for just quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full disclosure.
Here comes another familiar sovereign citizen theme. If an entity has a DUNS number or engages in financial transactions, then it must be a private business with no legal authority. He lists court and government agency registration numbers as if he's uncovered a conspiracy, when in reality governments keep financial records just like every other organization. That doesn't magically convert courts into fast food franchises. He compares the state of Michigan to McDonald's, insisting no one can force him to do business with them. But court orders are not cheeseburger coupons. You don't get to decline paternity, child support, or DNA testing the same way you decline fries. The law doesn't operate on customer agreement terms. The funniest part is that while he insists is not a corporation, he treats himself exactly like one, trying to opt out of regulation and responsibility by speaking in contract language. The judge, meanwhile, stays composed, because to the court these arguments aren't new, they are just consistently unsuccessful.
In Burns 322 BR 719, a creditor must provide proper documentation such as a promissory note, contract to substantiate a debt or court claim. They did not. More documents I filed. Affidavit inserting corporate nature of government entities. I submitted that document because I'm concerned that these are for-profit businesses disguised as government agencies. You know, I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Front of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses. I would like to state for the record that I am not a corporation. I'm a living, breathing person, human being. With these being businesses, they have to abide by the same rules as other businesses. And may I give an example? For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. None of these businesses that I've mentioned have my consent to do business with them. Section 458 of the Social Security Act, incentive payments to state. It's a conflict of interest. And it's my argument right here, right now, that the state incentivizes them it incentivizes them to collect more child support.
This section highlights another sovereign citizen misunderstanding, the belief that obligations only exist through contracts. Child support isn't a product you purchased or a gym membership you signed. It arises automatically from parenthood. The state doesn't need a promissory note from you to recognize that a child needs support. He keeps demanding to see a contract binding him to the case. But the legal relationship isn't between him and the court. It's between him and his children. Courts simply enforce it. Even the cases he cites don't say what he claims they do, which is extremely common in pseudo-legal arguments, long citations, confident delivery. completely wrong interpretation.
You don't miss any of
The
my
main
content.
argument I have here, and for you guys, is full disclosure. You know, it seems like they enter me in a contract without my consent, without full disclosure, and that's the problem here. You know, I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22. And it's basically evidence they didn't provide any evidence of an injury or injured party. And
Mr. Kraft, you're out of
Yes.
time. We understand that you raise issues of disclosure,
yes,
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue or the key tool that we use to resolve cases. And so I just want you to know, we have your brief. We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case. And then you'll get an opinion from us sometime within the next few weeks.
if I may, one last thing.
You've got, if you can do it in 20 seconds.
I can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I will ask you to dismiss this without prejudice.